My name is Meg Mott. I teach politics at Marlboro College, but most excitedly, I live in Putney, Vermont, and I get to speak to people in Putney about the amendments to the Constitution. We did this last year. We started with the First Amendment, and we worked our way through the second. We skipped the third. Maybe that was a mistake. It's about quartering soldiers in your house. However, that could come up in the not too distant future, so maybe we should go back to the third. But we did the first, the second, the fourth, the fifth, and the sixth, and then decided to take a break for the winter months and are starting up with the Seventh Amendment. Before we actually jump into the language of the Seventh Amendment, which is about civil juries, I'm curious, how many people in the audience have actually sat on a civil jury? Oh.
None of us? Well,
Civil.
Is that what you get called up for often?
Well, we got 3 hands up at least. So how many people have been called for a criminal jury? Okay. So more criminal than civil. And out of curiosity, maybe just to shout out some terms, can everybody hear me okay?
Yep.
So what is it like serving on a jury? What do you see as the advantage to serving on a jury? Anybody?
Well, I didn't serve. I was called, and on a case where there were millions of dollars of suit involving someone who'd been hit by a van, but who'd been riding the wrong way on the one-way street on a bicycle, the lawyer asked, is there anyone who has a problem with large monetary awards? And I stuck my hand up. So I got off that jury very quickly.
Uh-huh.
But then same group was called in for a criminal case, and that was really interesting. Not that I got to hear about, much of the case, but the judge did the most amazing introduction. He said that the facts were up to the lawyers, and that the decision was up to us, that this was a very serious crime with very serious punishments, and he proceeded to lay out, what it was a drug case. And I just thought it was astonishing. He had a group of maybe 30 people in the room, and he laid out the purpose of a jury trial and what was at risk for the defendant and what the DA and the defending attorney would try to prove. And I just thought it was the best civics lesson I'd had in my entire life, and it took maybe 20 or 30 minutes. It was amazing.
Wow.
Was it here in this area?
No, it was in New York City.
Wow. Wow. So I just wrote down judge as educator, which means getting some civic responsibility and an education. What were some other random thoughts, benefits of being on a jury? Yes, Virginia.
I've been called up 3 times on juries here, and one of them was a sexual assault case, a young girl, and the jury was not believing her. And I felt like the women on the jury were very important to be there, and I ended up being, at one point, the only juror who didn't want to let him go free.
Wow.
The father. And I felt like 12 angry men.
Yeah.
And I felt like I was so glad I was there because
Great.
I ended up we ended up finding him guilty on 1 count of the 3 he was charged with, which was at least better than nothing.
Yes.
Yeah.
So I felt like it made a difference in the outcome, my being there. And
You
I
were
was really very interesting.
And you must have had good skills of persuasion.
Well, you know what? It really made me realize how hard it is to be persuasive without being so emotional.
Yeah.
And that most people aren't very good at making good arguments.
Right. So another thing is it's a chance. Yeah.
I was just going to say, I think emotion is a large part of persuasion. I think when people see that it's not just an opinion, but it actually moves you, I think that speaks.
Right. And how often do we get this opportunity? So some other advantages to being on a jury, whether you've served on one or not. And then we're going to go over to the disadvantages.
Well, if it really were true that it's a jury of 1 peers,
Yeah.
that would be wonderful. But we know that, in fact, it isn't, but it's an attempt to be a jury of one's peers.
So I'm just going to write on the negative, because the way you presented that, Eva, peers under quotation mark.
Yeah.
Right. What is that? And we'll get into a little bit about differences in how jurors were called, especially jurors got far more diverse after the civil rights era, and then we start to see certain trends in the use of the jury system. Anybody want to say something else positive about the jury? Otherwise, we're going to move over to the negative.
I haven't been on a jury.
Do you want to imagine? Like, do you want people to serve as jurors?
Do I want people to serve as jurors? Very good question. That is,
Right.
it takes a lot of trust, I would think.
That could go in the middle.
So I guess to do that.
Yeah.
I've spent a lot of time in a country where there isn't jury trial. In Germany, you'll get a board of 3 or 5 judges who hear everything, so you have this feeling that it's priests reading the entrails of the sacrifice.
Wow.
And I think the fact that in the U.S., and obviously in Britain, where our system comes from, there's this belief in the common man to make a judgment, which I think is really fundamental to democracy. And that becomes a burning issue, of course, when jury trials stop happening.
Yes, getting at Janice's point about trust. When we have a functioning jury, we are showing ourselves that we have trust in just the regular person.
Right.
And not
in the system.
And in the system itself. Yeah. So just a few days ago, as I parked my car in the High Street lot in Brattleboro, and I'm leaving, and somebody says, "Oh, did you get let out too?" And I recognize this woman, but I couldn't quite figure out who she was. I now think I know who she was, but I'm not going to tell you her name. I said, "What do you mean get out?" She said, "I just got off the jury. They didn't want me," which is so good because I am self-employed and I don't know how long this trial was going to last, and I could have gone out of business. So she had a nice spring in her step because she got off the jury. So because I'm usually I am happy to make somebody else happy, I said, "Go for your liberation." And then I thought, oh my God, I'm talking about the 7th Amendment in Putney on Tuesday. I am so hypocritical, but I don't need to stop her now and explain to her how terrible her delight is. I wasn't going to do that. So, but certainly time
Time and financial.
and money, right, exactly, are super big.
Used for that.
Yeah.
Yeah.
Eva, you said something about peers. What are you getting at there?
Well, I was thinking about the issue of rape. She's talking about this young person being raped. A lot of times there is, and has been in the past, the attitude that these things don't exist for years. And having grown up in the South, also forget about it if you're were an African American dealing with.
Right.
I mean, it was so clear issues and crimes that were clearly not. You could blame it on a black person.
Right, right.
So.
And I'm going to write this down as confirmation bias, which is the term people are using now. That people come in with their biases, and then whatever you say to them just gets confirmed, as opposed to, Virginia had to go through an awful lot of persuasion in order to get people to get off their confirmation bias.
She's very persuasive.
Yes.
I went to Antioch with her, and I know she
Yes, there we go. Did you go to school with Hillary Clinton too? Yes.
I mean, I just think it must be really difficult because a lot of, depending on the issue, some of the stuff is really complicated.
Yes.
The law is very complicated, and frequently you're deciding on a technicality.
Yes.
It would seem to me where you might be very clear about the right or wrongness of the issue, the person did it or didn't do it, but
Yeah.
it sounds like there's complicating
Exactly.
circumstances that might sway it either one way or the other. And it would be very hard for me, I think, to separate those two if I really believed a person was guilty or not guilty, but
Yes.
the responsibility was taking me was forcing me
Exactly.
to make a decision based on technicality.
Yeah, which on contracts, especially for civil law, it's usually about a contract. It can get incredibly technical. Employment contracts. Okay, so this gets us started. Oops, and now I'm going to get back to my machinery. Yes,
The negatives for a minute?
yes, absolutely.
So I was once part of I can't remember what the issue was, But there must have been 50, 60 of us sitting, getting, the jury selection.
The voir dire, right.
Right. And it went on for hours and hours. And they were clearly picking, asking very pointed questions and picking people that they wanted, whose opinions were what they were looking for.
Yeah.
And it's funny, I don't remember if I served on the jury or not, but I remember sitting there and thinking, depending on how I answer these questions, I'm either going to be on or off this jury. What do I want to do?
Right. Yeah.
So it didn't feel like a very, fair is not quite the right word.
Right.
What word am I looking for?
I mean, equitable.
Just
Right,
equitable process,
right.
yes.
Because it's incredibly discriminatory.
Yes.
The lawyers get to have a certain amount of exclusions in terms of who comes on and, yeah, so it's quite the process. What?
I would like to focus us here. Shoshana was in trial in New York after 10 years of being underground, and there was, and they were going through picking jurors, and there was this Irishman, and Shoshana's history is Irish, okay, but anyway, he had an American flag pin, so the prosecution chose him. And of course, he's the one that turned the whole thing around.
Wow,
It
so
was
you
quite
never do
amazing.
know.
Yeah,
You never do know.
yeah, that's right.
All right, so this is great. We are so primed to think about juries.
would like
And
to
I'll
focus
use
us
the,
here.
Howard, what?
I would like to focus us here. Much of the conversation has been about criminal law.
Right.
And the Seventh Amendment is
Right.
about civil law.
Yeah.
And a very important point is criminal law is beyond a reasonable doubt. Civil law is preponderance of the evidence. You
Right.
do not have to have a majority jury verdict.
For civil, right.
That's right.
And can you see all right, Howard? Because there are seats right down here. I'm going to start using these slides now. Are you okay where you are?
If I couldn't, I wouldn't be sitting here.
Okay, excellent. All right, so here we are. This is a picture of the people deliberating. I'll use this. So a jury is a place of not just deliberation, it's also a place of adjudication. So it is focusing on something that happened or how to, as Howard said, with civil trials, how to resolve a harm. Public deliberation is something that we're also doing here. And I feel it's one of those skills that needs a lot more attention. So before we get going specifically to the Seventh Amendment, the reason we do public deliberation, and there's many different reasons, but these are the four that the deliberative democracy people recommend. It promotes legitimacy of collective decisions. So the fact that a jury looks at something and deliberates should enhance its legitimacy, as opposed to, as Ray was talking about, reading the entrails by some priestly character. So this jury should have this effect on our democracy. It encourages public-spirited perspectives on public issues. So when we're talking about the Seventh Amendment and several civil trials, we're focusing on was somebody harmed? How much damages did they incur because of that harm? Is the person who's being sued responsible, and how much should they pay? Or juries don't decide things such as you have to do something. It's all about assessing damages and then figuring out what the money should be. And juries should promote mutually respectful processes of decision making. So I'm hoping, Virginia, at the end of your persuasion, that there was a sense amongst all the jurors that what they were doing, they felt better about the whole process. It's not working well when at the end of the deliberation, some people feel as if they have been either disrespected, dismissed, or if people used manipulation in order to come to a decision. And this is particularly true of juries. They help correct mistakes. Whether it's a criminal case in which you are ascertaining that in fact the accused did something and that they are responsible for those actions, it's usually a fine or a prison sentence, or in litigation, in a civil suit, where the person who has been harmed, that the one who was sued actually was responsible for that harm, and the jury makes that mistake whole through monetary damages. I also wanted to throw in one other piece here. This comes, Lynn Martin sent me this last year as we did one of these series, and that it's really hard to be a decision maker. It's very hard to be out in public arguing with others. Would somebody be willing to read what P.D. James wrote, the first section?
There are two easy options for any society: total prohibition as in a totalitarian state, or total license.
Yeah. Elizabeth, do you want to read the next?
Both avoid the ardors of decision. Both have the attractions of certainty.
Right. There are strong reasons why we don't want to engage in deliberation. However, somebody want to read the third?
The difficult option is to decide where the line should be drawn, and this surely is the responsibility of any civilized and democratic country.
Right. So this is tough, difficult work to come together and deliberate, to have different opinions, and to figure out a response to it, a public response, not just a private response. So let's turn to this Seventh Amendment. Here it is. Anybody want to read the Seventh Amendment?
In suits at common law, where the value in controversy shall exceed $20, the right of a jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
Yeah. So how many people before you came here, I'm going to guess Howard for sure knows this, but how many other people actually knew the Seventh Amendment? Yeah. Hilda Marie, you read it in school. Yeah, right. Yeah, I was not as familiar with it. It doesn't get as much attention as the First Amendment or the Fifth Amendment or the 14th Amendment, which we'll talk about just a little bit tonight. This seems almost like it could be self-executing. It is that clear, with the exception of two words that get repeated. What is the common law? In suits at common law, this is, and they use the term preserved. They're talking about, usually people say it's the British common law, it's English common law. It is what laws were in place before we had our Constitution. Interestingly enough, as we'll see, people began to say, no, that's not the common law. In fact, who knows what the common law is? And who needs a common law? So these terms, which in 1789, that date may be a little off, when this amendment was passed, we could say there was a complete understanding from all the founders of what the common law was. But as we'll see, as things go forward and people start to put pressure on whether or not this is actually a right or whether there's a power, it starts to erode what that actually means. Okay, so let's go with the assumption that it's actually the common law of England, because it doesn't say that specifically. And the good place to go, if it were the common law of England, is Blackstone, who wrote commentaries on the law of England between the years 1756 and 1759. And this is a document that the founders used as they were drafting the Constitution and other legal acts. So according to Blackstone, the civil jury determines facts. Now, Ray, you said something about the fact that in the trial that you sat in, was that underscored? The juries
Absolutely.
determined
The
facts.
arguments would be made, but that the jury was to decide.
Right, right. So if it's a contract dispute, you're determining the facts. What did the contract mean? What did the person violate the contract? That is clearly underneath the powers, and I'm going to use the word powers right now, of the jury as opposed to a right. Blackstone says the civil jury allows the truth to be revealed through oral testimony and cross-examination. Because if it's not a jury, who's it going to be? A judge or a magistrate. Somebody who looks at the written record and does not take oral testimony. So when you have a jury trial, it becomes public. The witnesses have to come forward, evidence needs to be given, and people are able to cross-examine. So Blackstone said this is necessary. He called it the glory of the English law and the grand bulwark of English liberties. You don't have a jury, you don't have liberties. In 18th century England, under common law, juries heard cases to establish monetary damages, and that's usually, as I've been saying, because sometimes people do have a contract, they don't like how the contract is happening, and rather than saying, because this contract was broken, and say it was an employment contract, and I lost wages, and my children became sick, and I suffered emotional distress, my wife left me, you can't, if you're a jury, you can't make the employer do something. Juries can only establish monetary damages, which is the employer needs to pay something. So maybe that's too small a detail, but this has always been the case. Juries determine facts and juries establish monetary damages. The juries in England also gave damages to people who were falsely arrested. And this is important because it turns out these are not just private disputes, these are public incidents where harm was done by a state actor and a jury looked at the facts and a jury determined this should be the monetary damages. By contrast, judges could not overturn a jury's decision. So if a jury established the facts and a jury established the monetary damages, that was how it worked. Unless you were able to make these changes, there's always these little places, except through something called Demurrer, which is when the facts are looked at and it's clear there's no legal action, or non-suit, where the person who's bringing the case disappears or just says, forget it, I don't want to do this anymore. So there are these rare instances where a judge can intervene and say, sorry, this trial can't go forward. But for the most part in England, it was juries who did the bulk of the work, and the judge played a secondary role. In 19th century America, here's Alexis de Tocqueville. He thought the jury system was the greatest thing that happened. And he's coming from France, so it does not have a common law system. It has a civil law, is a little bit more like Germany, as Ray was talking about. So he looked at juries, and Tocqueville was very concerned about this democracy because he thought there would be the tyranny of the majority, and people, particularly he was afraid of a certain class taking on so much power that they would just run the whole establishment. As an aristocrat, he may have been most concerned about all the working class people or the debtors in society, but what he saw as a real break on the tyranny of the majority was the jury. Somebody want to read this first one, and we'll keep going through.
The jury may be regarded as a gratuitous public school, ever open, in which every juror learns his rights, enters into daily communication with the most learned and enlightened members of the upper classes, and becomes practically acquainted with the laws.
Yeah, and that's just what you described, Ray, of being on a jury when there is a judge who's able to explain what's at stake, who explains what the jury's role is, and how these laws, I mean, I love this idea of being in daily communication with the most learned and enlightened members of the upper classes. He's talking about lawyers. That's what he thought was the aristocracy of the United States. We didn't have a landed aristocracy, at least not in the North, but we had this lawyer class. And for people to become aware of how to talk about the law and know what a non-suit is, to know what a demurrer is, was incredibly important to him. So, but things started to go what we might call south in the 20th century. And this is a 1967 case, Duncan v Louisiana. This is a criminal case, but it is a case in which the Supreme Court said that right to a jury, not under the 7th Amendment, right to a jury, I think under the Sixth Amendment, I'm looking at Howard, is a fundamental right. Everybody should have a right to a jury in a criminal matter. 2 justices thought that was ridiculous. And they said, this is Potter Stewart and John M. Harlan wrote a dissent in Duncan v. Louisiana. And this is one of the things that, Janice, do you want to read this one?
Sure. The jury system is a cumbersome process, not only imposing great cost in time and money on both the state and the juries themselves, but also contributing to the delay in the machinery of justice.
Yeah, and notice the way they phrase this. They're not just saying that it's hard on the system, they're saying it's hard on the jurors. And yeah, that's true. It is hard on the jurors to do this. However, in 1967, that was not the prevailing opinion. But it became, especially for civil suits. So now we have the 21st century, and things have changed quite dramatically in terms of who has the power to do what. In the 21st century, judges are able to determine the facts. And the way they determine the facts is, first of all, prior to even beginning the trial, they can use, and this is Supreme Court language, they can use judicial experience and common sense and say, nope, this case can't go forward. This is not going to have a jury trial. They can do it during discovery, and that's when both parties are gathering information and they need to share that information. And they can, through a motion for summary judgment. So if one of the parties in a case, oftentimes it's the respondent, begins to think, I shouldn't be sued, there's nothing to this case, that one of the respondent can then file a motion for summary judgment, and the judge can look at that and say, oh yeah, that makes sense, there's not enough here to go to trial. And after the trial, a judge can overrule a jury by saying the damages or the verdict was not one that a reasonable jury should have made.
What?
Right. So after a trial, when a jury gives a verdict and then gives damages, a judge can say that jury was not reasonable, and therefore they throw it out. Yeah, that's what this is probably the saddest of all the amendments in terms of feeling as if, whoa, what is going on? The judges are taking over. So in the 21st century, who determines damages? Judges determine damages. Judges can reduce a jury's monetary award through remittiture. I don't know if I'm pronouncing that correctly. But that is when a judge reduces the amount of the verdict, usually when the amount exceeds the damages. And that became well known probably about 15 years ago was the McDonald's case. Maybe it was 20 years ago. Somebody got a hot cup of coffee and it spilled on their lap, and the jury came back with enormous damages, and the judge said, you're not going to go with that. Judges can order new trials if they believe the reward was excessive. So maybe, in that case, the new trial should have a jury with it. So it's not necessarily undermining the jury, but it just starts to add to the complications. And it's not just judges who are able to determine damages. Legislators also determine maximum damages for certain claims. So rather than having a case go forward and the jury decides, wow, that's $1 million worth of damage, now there's caps put on that. For instance, Title VII discrimination cases are capped by federal statute. Recently, the Supreme Court, I may get some of these facts, so please help me out with this, but there was a very recent decision in which the NLRB, the National Labor Review Board, was found that their oversight of these binding arbitration. Somebody want to help me with the facts on this? It was 2 weeks ago. Anybody know what I'm talking about?
Yeah.
Yeah.
Just that the companies can do binding arbitration now. Wasn't that just decided?
Right. Right, they can force binding arbitration. And in the past, they could go in front of the the NLRA in order to have their case heard, but that doesn't have a jury either. So there's places where, we can see how corporate influence is able to determine where these cases get heard. I wouldn't want you to think that progressives are totally behind the jury, because it turns out they're not. All of these administrative agencies do not have juries. So you might have gone to something like the NLRA to look at unfair labor practices, but you would not have gotten a jury of your peers. So it's a pretty bad situation. A book that I used to prepare for this talk came out this year. It's called The Missing American Jury by Suja Thomas, and it looks like a milk carton, right? Because missing persons, exactly. So according to law professor Suja Thomas, the jury has been eclipsed by a hostile Supreme Court. So it hasn't just been lack of interest on the part of citizens. What this book outlines are cases, step by step by step, in which the Supreme Court gives power to the judges and takes it away from the juries, which I didn't know before I read this book. I usually thought it had to do with lack of citizen interest. But what this book suggests is that actually it was a series of cases. So we'll go quickly through this dilemma of, here we have this Supreme Court versus the civil jury. In 1913, Slocum versus New York Life Insurance Company. At that time, the right of a jury is secured by the Seventh Amendment. So the Supreme Court reinforces the Seventh Amendment. It says that both the court and the jury are essential factors. It can't just be the judges. Both have to be there. To the former is committed a power of direction and superintendence. To the latter, the ultimate determination of the issues of fact. And that's what we had been under, that was what we had gotten from Blackstone as well. So this reinforces Blackstone's common law understandings of what the civil jury can do. However, in 1935, Baltimore versus Carolina Line Inc. v. Redman, which is known as the Redman Decision. Somebody want to read this?
The court concluded that a judge could decide the opposite of what the jury decided. Where the jury had found for one party, the judge could later dismiss the case in favor of the other party without ordering a new trial.
And this not ordering a new trial, now we're seeing where it becomes permissible to completely avoid any jury whatsoever.
And reaffirms the jury determines the facts.
Okay, so in 1935, there was quite a hit taken, and yet the primary function of the jury to determine facts was reasserted. Now we go to National Labor Relations Board versus Jones v. Laughlin Steel Corporation. This is a big case for people who are looking at the progressive era. It's usually heralded as a moment when the Supreme Court got behind labor and stopped just protecting liberty to contract, which protected employers and monopolies. So I hadn't ever thought about this case in terms of civil juries. I just understood it as a big step forward for labor in the United States. However, if you look at it, Congress establishes the NLRB to investigate unfair labor practices. And there was a lot of good reasons to do this, to look at labor in a broad way, that it was a congressional issue, not a local issue. But the NLRB now awards damages, not juries. The court said the matter was not a common law suit under the Seventh Amendment. When Congress establishes an agency, there is no jury trial right. And this is an important piece because the Seventh Amendment still just applies to the federal government. It does not apply to the states. It's not one of those amendments that were, as the term is, incorporated into the states, meaning that the states have to respect this amendment. But here you have Congress can now pass laws creating agencies in which citizens have absolutely no participation whatsoever. In 1943, Galloway versus United States. Somebody want to read this one? Lee. Okay.
The jury was not absolute master of fact in 1791.
Wow, so there we have a statement the Supreme Court says completely the opposite of what we saw in Blackstone and what had been accepted practice or accepted doctrine up until then.
The Seventh Amendment did not tie the judiciary to any specific procedure.
Mm.
The common law was continuously changing even when the amendment was adopted.
Right. So now that language in the Seventh Amendment that we were leaning on initially as this is the common law from England and follows Blackstone's understanding of what juries did, and not just Blackstone, it's what juries were actually doing in England, that idea, that interpretation has now been thrown into question.
For civil.
For civil, right. So this is where the 14th Amendment comes in. The 14th Amendment has made certain aspects of juries applicable to the state. The 14th Amendment, it's because of this language here. Nor shall any state. It's the 14th Amendment that takes the first 10 Bill of Rights and starts to say states can't engage in these practices as well. Nor shall any state deprive any person of life, liberty, or property without due process of law, that suggests juries, nor deny to any person within its jurisdiction the equal protection of the laws. And as I was saying, juries have been, to some extent, incorporated in. The Sixth Amendment jury rights were incorporated piecemeal. 1932, you get a right to a fair trial. Supreme Court says states have to allow for a fair trial for all defendants. 1966, the Supreme Court says right to an impartial jury. 1967, that's the Duncan V Louisiana case, right to a jury trial in criminal cases. We still have had no decision saying right to a jury trial in civil cases. So that Seventh Amendment does not apply to the states. The Supreme Court has not done that. So what happens if the jury stays missing? Professor Thomas says, somebody want to read this one?
The jury can perform important functions, including involving people in the operation of government on a more regular basis, thus engaging them in appreciating and policing the government.
And policing.
Policing. Oh.
Right, right. So this civic education goes two ways. It's a way to better understand the laws, to appreciate how the laws work, but there's also about policing the state. If you drew a picture of the different checks and balances in the United States scheme of justice, you would see the executive, the legislative, the judiciary, the states, and you could also say the jury as a actor, a constitutional actor. The jury is mentioned, I think, 3 or 4 times in the Constitution. So it's written in, and it is something that acts as a check on the other actors. But what happens if it's gone missing? So here's that language again. We can see how far the intent, perhaps, of the founders has been erased. Common law is now understood. Well, it's not something fixed, it's something changing. How can you preserve something that has been changing? And if you can change the rules so that judges are able to overthrow verdicts or overthrow damages, basically it doesn't really exist anymore. So I'm going to leave you with one, when we open this up to a conversation, and this is a little bit provocative because I know we've been talking a lot about the Second Amendment. We did that last summer, and some of us will be talking about it here on Sunday afternoon. One thing you can say about Second Amendment activists is they understood that it takes a social movement to keep an amendment alive. So if you're concerned about the civil jury, my question would be, what can Seventh Amendment enthusiasts learn from Second Amendment activists? And my first Second Amendment activists are the Black Panther, who were using the Second Amendment for arming themselves. For people who know something about the NRA history, I gather that after this happened, the NRA met in Cincinnati and took a very different tactic than it had prior to the Black Panthers. And now it looks perhaps a little bit more like here's a militia currently. And you may disagree with these use of weapons. However, as a political scientist, this has been an effective social movement for getting people to think about an amendment. So, yeah. So any questions or thoughts or wondering about the civil jury? Maybe we don't really need it. Yeah, Ray.
Well, the thing that stuck in my mind when I read the Seventh Amendment today was the $20. And $20 in 1791 is more or less $450 to $500 today.
Yeah.
So, I mean, if you think about the vast number of cases where you're over the $500 bar, and the whole idea that everyone with more than $500 in damages could have a jury trial, you know, there aren't enough judges and courthouses in the United States to do that.
Yeah.
When my grandfather was dying, he said, it's all gotten too big. And I, you know, kind of pushed him to continue that thought, and he said, our entire system, with all of the courts and so forth and legislatures set up for each state, was designed for a population of 2 million people. And we're now 150 times greater than that, and we essentially have no larger equipment. That, you know, New York City is 4 times the size of the United States, and it doesn't have, you know, 4 Congresses and, you know.
Right.
So
Right.
scale has become an enormous problem.
Yeah, yeah, right. I mean, there's argument that could be made. There's an argument that could be made that we are more of an administrative state and that we should be an administrative state because that is the only way to manage things at this proportion. And if everybody is going to be sitting in on juries, how are we going to have the gross domestic product that we want to have? Because it's going to slow everything down enormously. Particularly when it comes to civil suits. Maybe I want to be a little, like, does it really matter if juries don't hear civil suits? Yeah, in the back.
Is there a certain large percentage now, people don't really want to go to trial, so they kind of settle?
Right.
So isn't that kind of the...
Right. Right. So we have, what is it? When we were doing the Sixth Amendment right to a trial, that plea bargains are at about 95%. So even 5 or less than 5% of criminal cases actually go to trial. Because people would rather settle. They're nervous. Jurors have a reputation of being even more harsh. At least that's what a prosecutor will tell you. Yeah, Howard.
In federal cases, 1% go to juries.
Wow. Federal cases,
civil cases,
1%.
The federal cases in the United States, 1% go to juries. I'd like to offer a couple of clarifications here regarding first Blackstone. We looked at a bit of Blackstone. Actually, civil juries in English common law are much older than criminal juries. And at the time, you were right, the date is 1789 when they say, you know, suits at common law. That refers to common law as at 1789. There were courts in England that did not have juries. The equity courts, also known as courts of chancery, did not have juries.
Yeah.
And a minor point, but something, since we're sitting in Vermont, the Constitution of the state of Vermont does guarantee jury. It does not specify civil or criminal. Chapter 1, Article 12, and Chapter 2, Section 38.
Wow, wow.
So in Vermont, in state courts, jury is guaranteed.
Right. Did everybody hear Howard about how the juries are guaranteed in the Vermont Constitution? Yeah, Ray.
Except they're not. You know, I sit on a reparative board in Brattleboro, and I can tell you that there's the same process by which jury trial is avoided happening in Vermont. And sometimes that's to the benefit of the defendant, and sometimes it's not.
Yeah.
However, that is not my point. My point is that if you ask for a jury trial, you get a jury trial per the Constitution of the state
Yeah,
of Vermont.
right. And-
You were
and-
saying that the person waived a jury trial, which is not the same thing.
Right,
And-
but
and I-
often under enormous pressure.
Right,
That
right.
may be, but nevertheless,
And
the
this
right
is
exists.
this is really an important conversation, and it's the difference between what is the right to a jury as opposed to what is the power of a jury. And yes, there are a lot of constitutional protections for rights to a jury, and then we have to look at, well, on a practical level, how many people are actually wanting to go to jury, especially for criminal cases, when there's a lot of pressure to avoid going to trial in the hopes that you will get a better situation, whether through a diversion program, such as a reparative panel, or through a plea bargain, and you just pay a fine or take a lighter sentence, right? But then there's the other piece of, if a jury is supposed to be a powerful member of our whole system of justice, that's a different question. And if it is designed, if the whole system is designed to have juries, then what do we lose when we don't have juries? And I hear what people are saying, like $20 is not very much. The cases that go against big corporations for damages, I know the opioid epidemic, there's been efforts to try and sue the manufacturers of OxyContin. There was also efforts to bring felony charges against them in West Virginia. That story just came out in today's New York Times. But for litigants to think about what would it be like to have more of these cases being heard by civil jurors, as opposed to going through settlements, just lawyers, and the citizens stay out of it. So this is places where, because people just don't have the time, I think Janice's point about how complicated things get, did you get to that one?
Yeah.
Right, so things get super complicated and you're trying to understand what is a fraud case and what were the damages based on fraud, not criminal fraud, but negligence or something of that sort. Can a jury stay awake for months, perhaps, trying to sift through all these contracts, all these small print, fine print, and then come up with something? And right now, it appears citizens don't seem to want to do that. But Professor Thomas says it's not just citizens, it's also the Supreme Court has made it completely, you don't have any responsibility if you know that you can be overturned. So why put months and months into a trial when now a judge can just overturn the verdict or overturn the damages? So, yeah.
I mean, the thing that's hardest for me about all of this is to hold on to the fact that the Seventh Amendment is all about civil law. And that means in a litigious society like ours, you have occasionally enormous jury awards. I mean, the McDonald's case is one, and people argue about the significance of that. But, you know, one could argue that there are situations where a jury actually performs very badly in a civil case.
We're not offering, you know, a roadmap or sending a signal or a sign to the corporation or to who's ever doing this malfeasance that this isn't going to be tolerated. And if you look at the tobacco thing, for example, and how that grew because of the damages partly, you know. In terms of this complications technical thing, I mean, that to me is like a big piece of the problem because things are so complicated. You know, you could get 12 people who just with their common sense could make a reasonable, sane, smart decision if the issues were what the issues are rather than the technical
Right.
blah, blah, A, B, C, Q, whatever.
Yeah,
you
right,
know.
right. Yeah, it's one thing to get a legal education, and it's another thing to get a blah, blah, blah. This is just beyond my comprehension. I don't know what you're talking about anymore. And then you put a juror in that situation. That's not going to feel like a good civic education.
Yeah, I mean, and the fear of these big damages is a powerful incentive to corporations or whomever, you know, in terms of changing behavior.
Right,
One
right,
I
yeah.
think it has been, you know, you could give examples of that probably.
I mean, I think what's happening now, and I'll be interested what you all think about it, is that we have a court of public opinion. So there's social media that will start to make accusations against either a company that's selling a product and you should boycott this because of their, you know, like TD Bank, for example. People wanted to boycott TD Bank because of their connection to the Dakota Access Pipeline. So that is one way of affecting pressure or putting pressure on big corporations. But you're not deliberating. You're not trying to establish facts. You are trying to get your point across and persuade people, but you're generally doing it through a lot of emotional persuasion and not actually coming out with a better understanding of what actually went on. So this is where, as somebody who thinks of deliberation and this ability that we have to focus on something for a lengthy period of time and actually try and persuade each other, this is what I'm most worried about when we get these civil juries just not even happening anymore. I did try and get off a civil jury, I need to be perfectly honest. It was a terrible case, it was over Christmas time. It was a real estate case. I used to do real estate law in the 80s. It was a closing that just went out of hand, and I was a paralegal doing a lot of closings. I tell you, it was the 80s, it was Reagan, things were moving fast. I said everything I could to get off that trial, and I couldn't. And there I was, day after day after day, going through closing statements. And eventually they settled. But I was not happy to be there. I didn't think I would be able to persuade anybody. The kinds of conversations I heard with fellow jurors when we had our little recess and they were complaining about eyebrows, I thought, this is terrible. It's an awful institution. I hate the jury. I'll go on a criminal case anytime. I hate civil juries. And then I read this book and I thought, no, this is part of the whole big piece. We're getting fewer and fewer opportunities to actually try and persuade each other about facts. So, I don't know, maybe I'd go for it next time. Any other final, yeah, Ray?
Just an interesting factor, I mean, since the justice system in the United States have dubbed corporations persons, what's interesting to me is that a lot of the civil suits are now actually states against corporations. I mean, Janice mentioned the tobacco business, and what's really interesting are the cases where states are banding together to sue. And so in a way that's corporate, the state is standing in for the citizens. And I think that's a very interesting development in our system.
Yeah, right. So thinking about states as being the ones making the cases. And do you know if any of those cases are going to a civil jury or are they going to a congressional agency, or I don't know enough. Does anybody know?
Well, I mean, when you sue the tobacco companies for continuing to market stuff, that's got to be a jury trial.
Yeah, I would hope so.
I mean,
right.
And I suspect the suit against the manufacturer of OxyContin will be the same.
Right, yeah. In the back.
I'm just curious, with the Me Too movement, are those civil cases?
Right, so that's, I think of the Me Too movement as public opinion. It is not using any of the formal procedures to actually deliberate facts. So, I mean, it's a social movement that's getting a lot of attention. I don't see it as a, personally, I don't see it as something that should replace actual criminal courts, or if somebody's making a harassment claim, although those usually don't go to civil trials. Don't they usually go to the EEOC or something of that sort? So it's an agency and they don't have a jury. Is there something that you're thinking behind that question?
I've been involved in some discrimination cases,
Mm-hmm.
and, there are different laws in different parts of because you get different federal courts. But I'm thinking, if it doesn't go through a federal court, wouldn't it be a civil court? Like if I was a federal worker, but if the person's not a federal worker, couldn't she go through a civil court?
I'm pretty sure my understanding, and correct me if I'm wrong, is that if you work at a place that has, I think the cutoff is 50 employees, you need to go to the EEOC. So that's going to be an administrative hearing. That's the Equal Employment Opportunities. Thank you.
They usually give you a choice to avoid that and go straight to court?
I don't know enough about that. I thought that it was going to go through administrative law and not go through a civil court.
You can, I've been through EEO and I've been through, it came the second time, I went straight to court.
And did you have a jury?
It was split both times, it was settled.
Was settled, right? But you were about to have a jury.
The first time I was my own lawyer for a federal court
Uh-huh.
up against a U.S. attorney, which was kind of ridiculous.
Wow.
And,
A brave soul. That's great.
No, but I'm saying the odds are, and the judge had decided in his part of the state,
Mm-hmm.
his was a decision where I couldn't get any money out of it,
Uh-huh.
and it was his decision. I had that judge who had the law, so it was a no-win,
No-win situation.
Well, it was. They finally removed the fella.
Uh-huh.
Every time someone throws a pebble in, he gets enough pebbles and they finally get rid of him. But that doesn't always happen.
Right.
Second time it didn't happen. First time they got rid of the fella.
It's feeling like right now is if anybody can take a case and get it all the way to a civil jury, that should be a headline. And to say, can we bring back this missing jury? And this is on the endangered species list right now. And to understand that depending on where you take your case, if you can stay away from an administrative agency, you'll get a jury. Now that's not, I don't want us to sound naive, that isn't to say that juries are going to be blessed human beings. They're going to be human beings. But it will be an opportunity for people to work together, to persuade each other, to establish facts. And that's the piece that we're missing right now. So anyway, thank you very much for coming out on this Tuesday evening. Next month, the last Tuesday of the month, we're going to focus on the 8th Amendment, which is cruel and unusual punishment. I know there was some mistake about which amendment is which, but so we will be talking about capital punishment, I'm sure will come up, and efforts to try and reduce racial disparity in the criminal justice system using the unusual clause of the 8th Amendment. So we'll see how those strategies are proceeding. Great. All right, thank you very much, everybody.
And then amendment number 7 gives you 1 + 11, a trial by a jury of your peers. If it's cruel and unusual punishment, it's ruled out by amendment 8. Amendment number 9 says that other rights are fine, and 10 gives the rest to the states. Yo, it's the Bill of Rights, it's the Bill of your rights. It's time to take your knowledge up to unfamiliar heights, the thrill of your life, just like riding a bike.